So hello, my name is Jere Earlywine. I'm a lawyer with the law firm of Hopping, Green and Sams, and I'm going to be talking today about community development districts. And it is a fairly discrete area of law, but it's also an increasingly important one. For one thing, as a real estate lawyer, you may be involved in a project that needs infrastructure financing, and CDDs are a means of delivering that infrastructure. Secondarily, they're increasingly common in Florida. Of Florida's 1,600 or so special districts, CDDs represent about a third of those districts, and so it's likely that in a real estate transaction you might be representing a client in, you may encounter a CDD, and it has the potential to impact that transaction. So what I thought I'd do today in the limited time that I have is provide just a general overview of what a CDD is, talk about its powers and authority, its governance structure. I'll walk you down through the financing and assessment process, and then give both buyer and seller considerations in a real estate transaction. So what is a CDD? Well, a CDD is a special purpose unit of local government. It's established under Chapter 190 of the Florida statutes for the purpose of financing, constructing, acquiring, operating, and maintaining public infrastructure. They pay for roads and stormwater ponds, utilities, things like that. And they are an independent form of district. They're not a dependent district where it would be dependent on the city or county. Their budgets are not approved by the city or county. Instead, they operate autonomously with their own board of supervisors. One of the things that makes CDDs different than a single-purpose special district like a fire district or mosquito district is that they have a robust list of special powers. And in the materials that you find online that I'll provide, I've enumerated all those different powers. But like I said, they can finance roads, stormwater facilities, water, wastewater facilities. They can do hardscaping, landscaping, street lighting, conservation areas, environmental remediation, any project that's authorized by a development agreement with certain additional authorizations set forth in their enabling legislation. They conditionally provide for recreational facilities and security, mosquito control, fire services, and even schools. So it's a very broad range of authority that a CDD has. Now, they're not an unlimited form of government. They are a limited purpose form of government. So they're not going to issue, permits or make zoning decisions. All of the regular rules and laws that apply to development, the CDD would have to comply with when they're developing their own project. Now, a CDD is governed by a 5-member board of supervisors. And initially, that board is identified in the enabling legislation. And then shortly after the establishment of the district, there's a landowners election where the landowners elect 5 board supervisors on a per acre per vote basis. And then the terms are staggered, so you either have 2 or 3 seats up over the next election cycle, which is every 2 years thereafter. And again, those elections are on a per acre per vote basis until you reach 6 years, depending on the size of the district, and 250 residents living within the district. Once you meet those 2 criteria for your typical district, then the election cycle starts to turn over to a general election. It's held in November, just along with all your other elections. And at that point, it starts to turn over, and then you have general election controlling the majority of the board seats by about the 8th year. And of course, that's much earlier than what you'd have in a traditional homeowners association community where turnover might be 90%. With a CDD, it's much earlier. 6 years, you start having some residents on the board, and 8th year, majority control turns over. Supervisors cannot be removed absent some sort of abuse of an ethics law or something like that. So we talked about kind of the CDD powers and authority. We've talked about the governance structure. I wanted to mention, too, that CDDs are subject to all the same laws that govern other governmental entities in Florida. So, for example, the board supervisors have to meet in the sunshine at publicly noticed meetings. They also have to comply with Florida's public records laws. All of the records of the district are available upon request from an interested party. Third, the board supervisors have to comply with Florida's ethics laws that govern public officials. So all the prohibitions and the disclosure obligations apply to board supervisors just like a city or a county official. That means they have to disclose their financial interests on a Form 1. They have to disclose voting conflicts, and they have to disclose gifts over certain thresholds. In addition, they have to comply with all the voting conflict prohibitions. Obviously, public corruption, bribery laws, all those same things apply to CD supervisors just as they would to local government officials. And I think we touched on the fact that CDs have a broad range of authority, and there are a number of benefits and reasons why there's over 600 CDs in Florida. One of which is those robust powers and authority that I mentioned. It helps new growth pay for itself. CDs can help provide infrastructure for both new communities as well as to rehabilitate infrastructure in existing communities. Beyond that, CDs are actually able to issue bonds on a tax-exempt basis, and to secure those bonds, they'll levy a special assessment which gets collected on the tax roll. And this has a lot of implications, a lot of benefits. It means that the infrastructure can be delivered in a cost-effective way because it's using tax-exempt financing, which is typically cheaper. It also means that there's a very stable revenue stream supporting the repayment of the bonds, because once it's on the tax roll, they get collected, and the tax rate in a built-out community is just like any other taxes, 95 to 97% collection rates. So it's very stable. It's also great for residents and the local community, because the community itself gets to decide what level of service they want. If a community decides that they want to have a beautiful landscaped entryway, they can pay for that through their budgetary process. If they want to save money, they can scale back and decide to do that. In another community that isn't governed by a CDD, that may not be an option. So we've talked a little bit about the structure of CDDs. We've talked about the governance structure. We've talked about some of the benefits. Let's talk about the financing process next. And the financing process essentially has three prongs to it. First of all, there is you have to find a way to issue your bonds, and to do that, you go through a bond validation process where you essentially file a petition with a circuit court and ask the court to validate the CDD's authority and power to issue the bonds. Second, you need a revenue stream, and typically for CDDs, it's a special assessment levied on benefited property within the community. It doesn't have to be a special assessment. You can use impact fees and other types of revenue streams, but it's typically a special assessment. Once you have your bonds validated by the circuit court and you have your assessments in place, then you can actually move forward with the third prong of the financing process, which is essentially signing all of your bond-related documents, negotiating the terms of the sale of the bonds, and then closing. So there are a lot of different parties that are involved in this process. You have your district manager, who is responsible for maintaining the district's records, provide certain certifications in connection with the closing. You also have your project engineer, who will prepare a capital improvement plan outlining exactly what's going to be financed with the bonds. Are they going to do stormwater management? Are they going to do an amenity facility? All of that will be included in the capital improvement plan. You'll also have an assessment consultant, who often is also your district manager. That assessment consultant will take that capital improvement plan, and they'll lay out exactly what the assessments are going to be for each property within the community, how it's benefited, and how those assessments are allocated. That's what your assessment consultant will do. You also have an issuers council. Typically your district council will serve as issuers council and oversee the transaction from the district's perspective. There's an investment banker who will help negotiate the sale of the bonds. And you'll also have other parties involved too, like a trustee who will serve to, they're essentially the bank representative of the bank that will be serving as custodian for the funds from the bond proceeds. So those are the parties that are typically involved. There's also a number of documents that are important and that you're going to want to understand in connection with the CDD financing. You'll have an acquisition agreement between the developer and also the CDD that governs the acquisition of assets that are in the capital improvement plan from the developer once those are completed. You also have a completion agreement, which essentially says to the developer, if the CDD doesn't issue enough bonds to finance the project, you, developer, will be responsible for completing the rest of the project. You're also going to have a true-up agreement. What the true-up agreement says is that if there's 1,000 units that are initially planned to develop that project and support those bonds through the levy of assessments on the 1,000 units, and only 900 are built, that remaining 100 units, the assessments that would have been placed on that remaining 100 units will be paid by the developer as a true-up. There's also a collateral assignment, which is typically with the developer. It runs with the property. What that document says is that if there's a default on the bonds, the developer will assign over all the project rights that go along with the project permits and things like that. And then, of course, there's the indenture document, which is an agreement between the trustee, which is the bank holding the bond proceeds, and the district. And that indenture document essentially deals with the flow of funds through the trust estate and how those monies get paid out in connection with construction processes and things like that. And finally, there's a continuing disclosure agreement, which is an important document that obligates both the developer as well as the district to make certain disclosures of material events, quarterly filings, kind of providing updates on the numbers for the district, and so on and so forth. So that's kind of an overview of the financing process. One of the key parts, as I mentioned, was levying an assessment. And for an assessment to be valid in Florida, there are two requirements. First, you have to have a sufficient benefit from the capital improvement plan to the properties on which the assessments are being levied. In addition to the benefit threshold, you also have to establish that the assessments are fairly and reasonably allocated across all benefited properties. So those are the two requirements. And what you do, as we mentioned before, is the engineer will prepare a capital improvement plan, the assessment consultant will prepare a assessment methodology, and then you'll essentially bring those to your Board of Supervisors. They'll adopt a resolution declaring assessments, authorizing notice to all the landowners within the community, and then they'll have a public hearing where the board can sit as an equalizing board, receive feedback and comments from the interested parties, and then at the conclusion of that process, they'll essentially adopt a resolution that levies and imposes the assessment. And that's how you put the assessment in place. So I think we've talked a little bit about the financing, given a quick overview of the assessments. Let me give you also just a few practice pointers for real estate lawyers. First off, any lawyer who's approaching a transaction involving CDD needs to first do some title work and take a look at what's in the record. If you're not sure whether there's a CDD or not, there should be a notice of establishment which will announce the existence of the CDD. If the CDD has gone forth and actually gone through bond validation, there will be a recorded final judgment detailing the fact that the validation has been done and whatever threshold amount of bonds is authorized for issuance. That'll be stated in the judgment. If the CD has gone through and actually levied a special assessment, there'll be a notice of special assessments recorded in the public record. And then there should also be some consents. Typically, the developer will sign a consent saying that they're consenting to the assessments. If you have a mortgagee, there's usually mortgagee acknowledgement of the special assessments, again, consenting to them. So those are the fundamental documents you're going to find in the public record when you're doing some due diligence. In terms of buyer considerations, if I'm representing a buyer, there's a couple things I'm looking for. First, I want to get all of those documents I talked about earlier. I want to get the engineer's report, the assessment methodology, any assessment resolutions. I want to get all of those recorded documents. Additionally, I want to ask for the annual operating budget for the district. And what I'm going to do is I'm going to first look to see who controls the board, what's the election process been, because I want to understand that. Is it resident controlled? Is it controlled by the original developer or some other landowners? Once I've looked at that, I also want to take a look at the assessments, figure out how much is being assessed to my property or my potential property, and then also figure out whether I'm being treated fairly under the assessment methodology. Is there sufficient benefit? Are the assessments fairly and reasonably allocated? Those are questions I'm going to look at. Further, I'm going to look at all the different documents, the acquisition agreement, the completion agreement, true-up agreement. What documents are running with the property for which I'm going to be responsible? That's another pointer for a buyer. And then finally, I'm going to look at default scenarios. How far along is the project? What happens if it's not completed? Is there enough money in the construction account for the CDD to complete it? Or is the developer promising to complete the project? Am I relying on the developer to finish out this project? Those are all the different questions you're going to ask from a buyer's perspective. On the seller side, pretty similar analysis. There's a disclosure, though, that needs to be put into your sales contract. It's under Chapter 190, basically notifying the buyer of the existence of CDD. Additionally, you're going to want to get an estoppel letter from the district manager identifying the assessment levels, any true-up obligations that are owed, all those sorts of things you can provide through an estoppel letter. Further, I'm going to look again at those agreements and figure out which agreements I signed up for as maybe the developer of the project. I'm trying to transfer the project to a new buyer. Do I want them to be responsible for the completion agreement, for the true-up obligations? If so, I may need to get consent from the CDD's board because they're a party to a lot of those agreements, as well as possibly the bond trustee for the district. Many of the contracts have that provision as well. And finally, I'm going to try to negotiate a proration of the assessments with my buyer and make sure that that's fairly done as well. So that's pretty much all the time that I had for today to talk to you about community development districts. If you do have questions or have other interest in community development districts, feel free to reach out to me. I'm Jere Earlywine at Hopping Green and Sam's, HESlaw.com. Thanks so much for your attention.